Yes, madam is there. Joshna Sri, are you there?
No.
Okay. Madam also came in session.
Join.
Yeah. Okay, you can. Okay, you can start.
Good morning, everyone. Let me first take the privilege to introduce myself. I'm Josh Nasri, BA LLB student from SV University. Good morning, everyone. A warm word of welcome to the today's guest of honor and eminent speaker, Aishwarya Bhati ma'am. Also, a warm welcome to the guest of today, our Dean Faculty of Arts, B.V. Muralidhar sir. It's my pleasure to welcome all the participants today for the webinar on reproductive rights of women. Now, over to Vasavi, who will introduce and speak as well about our prestigious SV University. Vasavi.
I think Vasvi is not there in session. You will continue.
Oh.
Joshna Sri will continue with.
Good morning, everyone. Our prestigious SV University, commonly referred as SV University or SVU, is a public state university located in Tirupati, Andhra Pradesh, India. The university is named after Lord Venkateshwara, whose shrine is located in the city. The university was founded in 1954 by then Chief Minister of Andhra Pradesh, Tanguturi Prakasham Pandalu, with Sriram Govindarajulu Naidu as its founding Vice Chancellor. The university campus covers a large area on hand leased by Tirumala Tirupati Devasthanams. It is located on the west side of Tirupati, surrounded by the other universities in the city, namely Shri Padmavati Mahila Viswavidyalayam, Shri Venkateshwara Veterinary University, Shri Venkateshwara Vedic University, Shri Venkateshwara Institute of Medical Sciences and National Sanskrit University. This is all about a small competence note about our university. Now over to Jita, who will speak about our respected guest of honor and eminent speaker Aishwarya Bhati ma'am, Additional Solicitor General of India, Senior Advocate, Supreme Court of India. Jita, over to you.
Thank you, Joshna. Good morning, one and all, to the respected Aishwarya Bhati ma'am. Thank you for having you, ma'am, here. And it's a privilege to talk about you. Thank you for this golden opportunity. I also welcome Muralidhar sir. Good morning, sir. And good morning to all of my friends who are joining at the webinar. I am Jita Maitreyi. I am pursuing my LLB first year in the prestigious university, Sri Venkateswara University. So today I am here to introduce my knowledge about Aishwarya Bhati ma'am. So Aishwarya Bhati ma'am was born and brought up in the beautiful sun city of Jodhpur in a traditional family with strong culture and the value system. So which was also an Indian Air Force family. Aishwarya ma'am charted her professional journey as a litigation lawyer. She has the distinction of being the youngest woman lawyer and the only one from Rajasthan to be conferred the designation of a senior advocate from the prestigious Supreme Court of India. She is also one of the youngest additional Solicitor General of India and the fourth woman in the country to occupy this coveted position. Aishwarya ma'am was passionately fought for the women's rights, children's rights, rights of persons with disabilities, sustainable environmental laws, and also a crusader advocate for anti-tobacco litigation. She has led from the front the rights of women officers of the Indian Air Force, Indian Army, and the Indian Navy for at par consideration for permanent commission and the commission positions. So about the professional standing of Aishwarya Bhati ma'am was professional standing for nearly 24 years at Supreme Court of India. She had been working as Additional Solicitor General of India since June 2020. So she was also designated as a senior advocate by the Supreme Court of India in March 2019. So also advocate on reward of the Supreme Court of India for nearly 13 years prior has a designation as a senior advocate. She also became a volunteer at Supreme Court Legal Services Committee, Supreme Court Middle Income Group Legal Aid Society from the beginning of her professional journey. So she had completed her 12th from Kendriya Vidyalaya Air Force from Jodhpur in the year 1992. She also done BSc from KN College, JNU University from Jodhpur at the period of 1992 to 1995. Ma'am also pursued her LLB from Law Faculty, JNU University from Jodhpur, which she has also won a gold medalist from the term 1995 to 1998. Ma'am also completed LLM from Law Faculty, JNU University, Jodhpur in 1998 to 2000. So thank you, ma'am, for having you here. It's a really honor for me. Thank you.
Let's now begin the vital segment of today. Today's webinar is about reproductive rights of women. Before I invite our eminent speaker to speak about the
ఆన్లైన్ వెబినార్ లా గురించి ఒక టాపిక్ గురించి ఒక ఫేమస్ లాయర్తో
I request all the participants to mute your mic.
Shavani, I think you got to mute your audios. Mahendra and Shavani, confirm it. Please check your audio. Please check your audio. I think Mahendra. Yes, that's good. Please, when the speaker is delivering her address, kindly mute your audios, if not videos. Keep that in mind. Thank you.
Okay, now let's begin the vital segment of today. Today's webinar is about reproductive rights of women. Before I invite our eminent speaker to speak about the topic, I would like to give a glance idea regarding today's topic of the webinar. Historically, the reproductive rights movement in US has seen many controversies due to the moral, ethical, and religious undertones of birth control, abortion, and family planning. Today, the subject of reproductive rights continues to be an emotionally and politically charged issue, especially in light of new technologies and recent laws. In general terms, reproductive rights are the rights of individuals to decide whether to reproduce and have reproductive health. This may include an individual's right to plan a family, terminate a pregnancy, use contraceptives, learn about sex education in public schools, and gain access to reproductive health services. This is a compendious note on today's topic. Now I invite our guest of honor, eminent speaker, Aishwarya Bhati ma'am, to speak about the reproductive rights of women. Ma'am, please.
Thank you, Jyotsna ji. I hope I'm audible to everyone.
Yes, ma'am, you're audible.
Thank you. So a very warm good morning to everyone. And I seek to have the blessings of Lord Venkateshwara through all of you. You are lucky to have a campus in his name, in his vicinity, under his shadow, and with his blessings. So I also seek to invoke those blessings. Dean sir, and all the entire team of the college, the law college, and all the dear students. Thank you very much for having me here. It's interesting that the topic that you chose is a topic that I have done a very interesting matter on recently. So I I did a very comprehensive research, me and my colleagues. We had a very comprehensive research. I'll tell you about the case a little later. But let's start with what really constitutes the reproductive rights of women. Now, reproductive rights are not really defined separately in the Constitution. It comes into the ambit of Article 21, which is the right to life, because it is an integral part of a woman's life. It also has some shades from Article 14, because Article 14 prescribes equal protection of laws to all equals, That's the affirmative action equality is what our constitution prescribes. Our constitution does not say equality of all, irrespective of whether they are equally placed or unequally placed. That is why affirmative action for women. And then there is a directive in the directive principles of state policy in the constitution, which specifically mandates the legislature, the governments, successive governments, to comprehensively work on equal opportunities for women in workplaces, equal pay for equal work, also maternity relief benefits, maternity leaves, etc. All those benefits are mandated under the Part 4 of the Constitution, which is the directive principles. Now, a lot of those directive principles have resulted into laws. So they don't remain in directive principles. They are now contemplated and strongly protected by specific laws. So that is really the scope under the Constitution for the reproductive laws for women. One more aspect that we should look at is, when we speak about reproductive rights, we need to also look at how the world was treating this. So we will go into a little bit into the Roe v. Wade judgment and how it has been reversed by the recent Dobbs judgment of the US Supreme Court. But before we dwell into the topic a little more, I want to request all of you, I requested the organizers also, that I would like this to be more interactive. Since I am here interacting with all the students of law who are studying law, I am also a student of law who practices law. So I would like this to be interactive. I will give you a overview of the topic. I will give you some nuances of the topic, and I will give you some case law study also. I'll share some of those. Jyotsna ji, would you please mute yourself? And Mr. Raja also.
Ma'am, can you please unmute your ma'am? We'll all.
Yes.
Yeah, now it's okay.
Pawan,
Actually,
అందరిని మ్యూట్ చేసేసేయండి మేడంది తప్పించి
చేసాను.
అందరిది మ్యూట్ చేసే.
Don't worry, sir. This usually happens on webinars. We end up making it's not intentional, but it's just bona fide mistakes that keep on happening. But it's okay. We'll just continue. So what I wanted to tell you is, if you have any thoughts, any questions, any queries, any comments to make, I would like this to be interactive. So let's make it more interactive after I share some of my thoughts with you, so that you have an idea of the way that I perceive this law to be. This very important right to be. Now, before we go into the specifics of it, I think the first and most important act that we need to look at is the Medical Termination of Pregnancy Act of 1971. Now, before this act came in 1971, this act comes. And before this act came in, it was an offense under the IPC to cause the death of a quick child. Now that offense would inculpate not just somebody who was helping with the abortion process, termination of pregnancy, but also the woman. Also, the woman who was undergoing that process would be liable under that IPC offense, and it was a very stringent provision of law. But historically, we have to understand that like Jyotsna briefly mentioned in the beginning, this is a topic which is not a purely legal topic. It is a topic which has deep inroads into social life, religious lives, the religious beliefs of people, and the modern way of life, and really the trinity and the junction of all of these beliefs and thoughts and requirements of reform. So one more aspect I must give you, that when rape was introduced as an offense in the IPC, rape was not considered as an offense against the woman. Rape was considered against women were treated as chattel, and she would be the chattel of the father if she was unmarried, and she would be the chattel of the husband if she was married. That is 2 centuries back when it was contemplated. So rape was taken as an offense of the highest level of property, because woman was taken the highest form of property for a man. And rape was an offense. If the woman was married, it was an offense against her husband. And if the woman was unmarried, it was an offense against the father. So with that kind of mindset, where the violation of her own body was not considered as a violation of her personal autonomy, her integrity, her right to life, giving or contemplating a reproductive right to women was far-fetched. This changed slowly. That is why 1971 is when the most significant change is made, when Medical Termination of Pregnancy Act comes, and it makes an exception. It carves out an exception from the Indian Penal Code. And I would commend to you the statement of objects and reasons of that act of 1971. It is very critical to note that the reason why the statement of object clearly notes that this is really to safeguard the health of women, the physical and mental health of women, because what the country was experiencing was that when women were suffering from any medical problems, scores, dozens and hundreds of women, when they came for medical assistance, the doctors realized that their uteruses had been tampered with by these illegal, unethical, covert, clandestine kind of termination of pregnancies that were happening in the absence of any legal safeguard being available to women. So that is really the object of the Medical Termination of Pregnancy Act when it came, with a specific view to allow women, to give women a right and access to safe termination of pregnancy. This was a watershed moment, and this 1971 Act has undergone a very significant amendment last year in 2021. So 2021 amendment is landmark for 2 or 3 reasons. The first is that the medical termination of pregnancy was allowed up to 12 weeks of the pregnancy, and in exceptional cases, up to 20 weeks. Mr. Raja. Okay. So what happens is that so this period was provided 12 weeks for normal circumstances, and for 20 weeks, up to 20 weeks for exceptional circumstances. Now this 2021 amendment is on account of the scientific development that has happened, of the medical developments that have happened. So keeping in mind that, what is now prescribed is that up to 20 weeks, a woman has the right of medical termination of pregnancy if it impacts her mental or physical health adversely in any manner, and it prescribes that if it is a failure of a contraceptive device, etc., then it will be taken, and the woman's circumstances, the present circumstances, and reasonably foreseeable circumstances are significant for ascertaining what will be the impact on the mental and physical health of the woman. Second very important change that the 2021 amendment makes is that it, for the first time in the Act, includes a woman and her partner. So the 1971 Act read married woman and her husband. That was the contemplation of the 71 Act. But the 2021 amendment very specifically says woman and her partner. This is keeping in mind, so it makes no distinction whether a woman is a married woman, whether she is in a marriage, whether she is in a live-in relationship, whether she is not in a relationship. It makes no distinction between the reproductive, the right to choose, the right to choose her, her reproductive system. So that makes no distinction. And the third very significant thing that it makes is it protects the privacy of such woman by law. It is mandated by law to protect the privacy of this woman. Now let me speak about the interesting case that we were dealing with. Just last week, we finished arguments on that. Judgment is reserved, so I will not make any overtones on that. But I just want to tell you, as students of law, how we prepared the matter and how we brought it, the kind of submissions that we made before the court. So the court was confronted with a very peculiar situation where this woman was an unmarried woman in a live-in relationship, and she had crossed 20 weeks of her gestation. So 20 weeks for the normal course that is provided in the 21 amendment. So after 20 weeks, only extremely vulnerable categories of women are can have a medical termination of pregnancy, because you don't, as the gestation increases, it increases the risk of life and health of the woman. Also there is quickening of the fetus, etc. So that so the medical science only recommends that only up to 20 weeks it should be a normal procedure. It should be a open procedure and accessible to all. So this woman was beyond 20 weeks. Her pregnancy was a result of a live-in relationship that she was in, and after her pregnancy got discovered, her live-in partner left her. So she felt extremely vulnerable. She was one of 5 siblings. She came to the court saying that I can't handle this pregnancy. I have no job. I'm just a graduate. I have a lot of family responsibilities. And now that my partner has left me, I can't carry this pregnancy to full term. So the reason why she was being denied the right to medical termination of pregnancy was really a provision in the rule under the MTP rules, the rules that are framed. The rules are also framed in 1973, and the rules also came to be amended in 2021. But still, sorry, the rules are of 2003, amended in 2021 again. So these rules made this category of extremely vulnerable women, and this prescribed that these 7 categories of women would be treated as extremely vulnerable. That was, rape victims, minors, women with physical disabilities, mentally ill women, fetal deformation or malformation, and women who were in humanitarian crisis situations. So for them, they were treated as extremely vulnerable. And there was one more category in this: if there is a change of her marital status after the pregnancy, and that rule says change in marital status, that is widowhood or divorce. So it specifically contemplated only 2 categories of married women. If the woman would become a widow or a divorcee during the course of her pregnancy, then she would be treated as extremely vulnerable. This was one particular provision that the court wanted to interpret, because this woman had challenged that and said that if you are in the main act is providing the remedy to an unmarried woman, then the rule cannot constrict it to a married woman alone by defining it change of relationship, change of marital status only for the purpose of divorce and widow. So this provision came to be challenged, and then the court looked at the provisions, court looked at interpretation, etc. It's reserved for judgment. The judgment will come. But see, what an interesting proposition of law that came before the court even after the 2021 amendment. And then the court was looking at it, whether it should be expanded for all categories of women, or should it be expanded only for this category of women when you treat. Now, some interesting other statutes that the court considered, which we also produced before the court. I think it is important even for our topic. First is the Maternity Benefits Act of 1961. Now, this Maternity Benefit Act of 1961 is a result of the Part 4 directive to the state that you will ensure more human conditions of maternity for women and equal opportunity in public employment. So this Maternity Benefit Act of 1961, which is amended by several amendments. Most significant amendment really came in 2010. And it defines a woman to include any woman who's in employment, making no distinction between whether a woman is married, unmarried. It gives her that benefit. Then it specifically mandates as a sanction of law that a woman will be entitled to maternity leave, maternity benefits, not just when she is having a child, but also there is contemplation of leave and benefits at the time of her termination of pregnancy, because termination of pregnancy is also an important medical procedure that the woman needs to go through. So this is an important act. This is also an important act because there's another aspect to it. Reproductive rights do not end when either the child is born or the woman has exercised her right of a termination of pregnancy in case of unwanted pregnancies within the contemplation of law. It also includes women who exercise their reproductive right to give birth to a child. Now, that is a significant aspect which also needed to be addressed, because many of the women who exercised their reproductive right to and had a child were faced with this dilemma in their workplaces, whether they come to work or whether they choose to take care of their children. Because, woman is not a superhuman being. You can't, and a child is a full-time job. It's more than a full-time job. And if you have a full-time job, more than a full-time job in your hands, then how does one look at the responsibilities of the workforce? So a lot of women were dropping out of the workforce. They were not able to continue with their careers, their professions, their livelihoods, their jobs. Therefore, this benefit of maternity leave, maternity benefits, and one more important, significant aspect that has come is the mandate of law requiring creches in all institutions which employ more than a certain number of people. So those creches, I can tell you from my practical experience, in Supreme Court, we never had a creche for the longest period of time. We've had a creche only for the last 6-7 years now. In fact, the first time creche was opened was when we had Chief Justice Dattu. Chief Justice Dattu was the Chief Justice of India, and I was incidentally the Secretary of the Supreme Court Bar Association. So that was the first time that a creche was opened. And a lot of women lawyers who otherwise would have fallen out of the profession because there was nobody to look after their child. It's very difficult if you put a mother into that dilemma, whether you choose your child or whether you choose your profession. That dilemma should never come to a woman. There should be mechanisms available for women to continue with their professions, with their jobs, with their vocations, even after becoming mothers. Now, this problem has become even more exaggerated because our systems of joint families have deteriorated a lot. Now we have nuclear families, single parent families. So a lot more support is required. It is often said it takes a village to raise a child. And one parent or just, one set of parents can never be that whole village for the child. It takes, and having a child is a very important aspect. Not just look at some of the European countries, they're having births in negatives. We of course, on our country, we don't have that problem. In fact, we have the problem of plenty. But that is also a strong asset for us. India is going to be in fact, the youngest country of the world for the next 40-50 years also. So that young workforce, so imbalance if it goes. So see, we need to have lesser population, but then that imbalance cannot happen, that you have more old people who are not contributing to the nation and you have yet less young people. So that balance has to be there so that the older generation and the older population can enjoy the benefits which are provided by the society living, nation living, while the younger generation can continue and contribute more to the workforce. Now, looking at some of the aspects, I think let's look at some international practices, because this is also an issue strongly debated world over. I think you would all know about the Roe v. Wade judgment. Yeah, so Roe v. Wade was a landmark judgment of the Supreme Court of United States. This judgment came in 1973. And why this was significant was this judgment made it a part of right to life, a part of the 14th Amendment of the US Constitution, to read into this aspect that right to life includes right to privacy, and it includes the woman has the reproductive right to herself. It is her right that is sacrosanct, and it is a part of a fundamental right, and it has to be protected in that manner. Now, this judgment has stood the test of time for the longest period. It was a 1973 judgment. And just this year, we have seen another judgment, which is the Dobbs versus Jackson Women Health Organization judgment. Now, this is a judgment that has reversed the Roe v. Wade on the reasoning that the constitution makers did not contemplate an expansive right of privacy. Even right to privacy itself is not contemplated, and therefore a reproductive right reading into what the constitution makers did not contemplate amounts to judge making law, and that is not the correct approach. That's what the US Supreme Court feels. And they say that if an intervention has to be made, it is the legislature which alone can make an intervention. So this has really added a lot of confusion, left the field open. You all would be aware that US is a strictly federal country. They have very strong division of powers between the states and the federal structure at the unified at the central, at the core level. So every state is entitled to make their own laws in a lot more domain areas, and even if there is a federal law, the state law uh, will supersede the federal law when it comes to the specific state. So now it has become it's become a completely chaotic situation where more and more states, on the basis of whether they are red states or blue states, are coming up with laws allowing or banning abortion in totality. And that has led to women not having access to safe abortion procedures in particular states, medical practitioners not being allowed to, and even in exceptional situations. I don't know if you will remember, just 5 years back, there was a woman of Indian origin in Sweden that led to a reform in Sweden. I mean, it's one of the most developed countries, the Scandinavian country that, the country that everyone, that pocket of country that everyone considers are very well developed, very high happiness quotient in the Scandinavian region of countries. But the reproductive rights were such that this woman, despite her medical conditions, she bled to death. The doctors could not intervene, could not give her the benefit, could not give her the medical intervention that was required, and she ultimately lost her precious life. Life was lost along with the precious life of the fetus that was inside her because of the medical problems that she suffered. So this is the contrast. The contrast is that some countries are not allowing medical termination of pregnancy, even where it is a danger to the woman's life and health and her well-being. And some countries are allowing that as a fundamental right. Nepal, for example, has a fundamental right. In their new constitution that they wrote, they made it a fundamental right. So some of these aspects are continued to be debated. Now, India, in our constitution, our constitutional interpretation is not like the US Supreme Court. We don't, we believe that our constitution is a dynamic, organic, living document. And it continues to interpret it. It needs to be interpreted with every generation. In fact, one of the famous lines of a constitution bench of Supreme Court was that constitutional morality, constitutional principles, and fundamental rights are like empty vessels. Like you have a vessel, it's an empty vessel. And every generation has to fill in those vessels, empty vessels, with its own wisdom. So what is, correct today could not have been in contemplation 100 years back. Now, US Constitution was written almost 230 years back. Indian Constitution was written almost 73 years back. Now, US Supreme Constitution, let me give you an example. 230 years back, US used to practice slavery. US did not give women the right to vote. Women were not part of the franchise. Women were considered strongly as a chattel of the man. So how could that interpretation of constitution be allowed to today's requirements, today's way of life, in a manner to scuttle the rights that are strongly available and embedded as part of the human rights? Now, United Nations Charter, etc., is also very clear on this. Reproductive rights, it calls for removal of all forms of discrimination between women, in women in developed and developing world both. In fact, the world is progressing in such a manner that now there is a legislative sanction to even more, more advanced and developed reproductive rights, which is like right to surrogacy. Surrogacy is also a phenomena that we have seen in recent years. And though initially surrogacy became a way for, trying to maneuver women from the lower strata in a manner that it was violating their rights also, but the surrogacy bill that has formed into an act in India now has very strict regulation in place. We don't allow surrogacy for pecuniary benefits. It is not allowed in the new act which regulates surrogacy. It is allowed only if it is between between relatives, between family, and what is the right of children who are so IVF procedure, the assisted reproductive rights, reproduction, etc. So what are the rights that are available to women in that? So these are and one more aspect, I think adoption is also one thing that we must speak about when we discuss reproductive rights, because adoption is also under the Indian context. We have personal laws, of course, so it's our personal laws that govern. Adoption is one of the element of personal laws, but adoption is one aspect that has come out of personal laws. So now the adoption procedure, though adoption initially was prescribed only under the Hindu law, the Hindu personal law prescribed it because they believe that under that belief that if you don't have a son, then you don't get moksha, etc. So adopting a son was considered the way of life for a Hindu. It was not contemplated in any other religions. But now under the Kara guidelines, under the Supreme Court judgment and the Juvenile Justice Act, adoption has become a gender neutral and a religion neutral process. And again, women are allowed to adopt irrespective of their matrimonial status, whether they're married, single, they can adopt a child in India. So this is the gamut, I feel, of reproductive rights that I felt it was important to give you this perspective. Now, if anyone has anything to say, speak, comment, ask, please let me hear what you feel about it. I want this to be interactive, so I also understand that how the younger generation is looking at this. Thank you very much.
Thank you so much, ma'am. Huge gratitude to you. It's been a great lecture and you're a terrific speaker. I would like to say that to all the participants, there is doubt section. You could convey your doubts. You can interact with ma'am. You should chase this wonderful opportunity. Before we move to the doubt section, I would like to speak about our Dean Faculty of Arts, and we'll also ask sir to share his views regarding the today's session. So our Professor Dean B.V. Muralidhar sir is presently the senior professor and head in the Department of Political Science and Public Administration and head of the department for 5-year BA LLB program, SV University Tirupati. He was former principal and chairperson for the Department of Political Science off campus Dravidian University, Kuppam. He did his master's in 1985, MPhil in 1987 and doctoral degree in 1995 from the same university. His area of specialization and interests are international relations, foreign policy. Professor Muralidhar sir is also a social service activist and doing social service with his family since 4 decades. Now I would like to request sir to share his views regarding today's webinar on reproductive rights of women. Sir.
Hello. Kindly excuse me. It's better to have an interaction, then I can speak for a few minutes. Better to have an interaction because I'm the odd man out. So better we have the interaction because there are so many people from the Department of Law and others who like to have an interaction with the speaker.
Okay, I request all the participants to share your views, doubts, or else you'd like to interact with ma'am, you can.
Good morning. Is it okay if I speak or should I type?
Fine by me if the organizers are okay.
Okay. Thank you, ma'am. Thank you, SVM and all the organizers. One question which I have is, does the woman have complete autonomy on taking a decision for the abortion or the reproductive rights, or if she's married or if she has a partner, does she needs to take consent?
So, Ibrahimji, thank you for your question. There is no requirement in the law for a consent to be required from the partner, because it is the woman who will be bearing it. Even if she has a spouse or a partner, there is no requirement of consent. But please appreciate that termination of pregnancy is on the consideration that it impacts her mental or physical health in a adverse manner. It is prejudicial to her mental or physical health. So that aspect is something that a medical practitioner has to consider and certify. Only then failure of a reproductive device of a family planning device is considered. It is deemed to be amounting to mental cruelty. Actually, this is also a debate, in the whole world. There is a whole debate where the partners and the spouses are saying that our say should be important in this. But there is a strong resistance. In fact, I saw the provision in the Nepal constitution. There also, I was told, I was interacting with one of the Supreme Court judges, a very prominent woman, who was instrumental and part of the drafting committee of the constitution. And she was telling me that in Nepal also there was a lot of debate that the men should have a say. But the problem with men having a say in the woman continuing with her pregnancy or terminating her pregnancy is that then this goes down a slippery slope, because then how do you hold the partner or the man accountable after the pregnancy, after the childbirth, to be equal stakeholder or shareholder in that childbirth process? So I mean, I think sensibly, if you can keep your partner on the same page, I think it has to be the woman's call. But I think it's important that men who are partners or spouses in a relationship, there should be no problem in the relationship for the woman not to do something against the wishes of the man. If there is a problem, then it has to be her say that has to prevail.
Thank you, Ibrahim Sheikh, for your doubt. Any other participants, if you would like to ask anything?
Hello. Hello. Good morning, madam. Hello.
Yes, Samanik, you are audible. You can speak.
Yes.
Samanaik.
Good morning, madam. Nowadays, the school education or college education or university education, or they have introducing the C team this year, some programs. This impact of the sexual harassment programs. How can impact the freedomness, madam? Hello.
Sorry, I didn't understand your question, Samanik ji.
Madam, for the school days or college days or university days, after they are introducing the one program, sexual harassment, sexual abuse, the Disha team or C team, how can impact on the there are freedom, no madam, you said freedom. Yes. Freedom of a sexual women, but there is no freedom, no madam, all introducing the schemes. How can possible, how can justice?
Samanik ji, I feel that it is very critical to introduce these this whole awareness process about sexual abuse in the curriculum. I think it's very important, because if you look at the statistics, the sexual abuse of women happens 50% or more of that sexual abuse happens in places which are places of confidence for the woman, which could be her home, her larger family, her workplace. So see, crime is one aspect where strangers are are causing a sexual assault on the woman, but crimes where it's not strangers, it is people who are supposed to be in a position of protection for the woman. If they are abusing that, this is very important, and we need to have more safe spaces for women. See, one half of the workforce of the country will not be able to contribute to their fullest if they don't have the basic safety there with them. So I feel it is important. It is extremely important because this adds the atmosphere of protection. I mean, today it's not, if a girl's parents don't feel that their child is safe, if the young girl is safe in going out, working, studying, then they will keep those girls at home. It will be very detrimental to the progress of the nation. That is why it is important to have this awareness, because laws and rights are there, but unless we have the awareness, women won't be able to stand up and speak.
Yes, madam. Now as per the curriculum, as per reproduction, the syllabus, they divided to they have explaining or co-education or general education. That is the main cause, madam.
I think with more awareness, things will get better, Samanaji. That's what I feel.
Yes, madam. Thank you, madam. Thank you very much, madam.
Thank you, Samanai.
Thank you, madam. Given opportunity. Thank you very much, madam.
Any more participants, if you'd like to ask anything, you can share.
Good morning, ma'am.
Are there any more participants who would like to ask or share anything?
Good morning, ma'am. Can I have a word, please?
Yes, you
Ma'am,
can
I
go
have
ahead.
a doubt. Thank you, sir. Thank you, ma'am. I have a doubt that if a pregnant woman has a will to carry her baby and she want to have a child, but she was forced by her partner or the spouse to abort the baby, then is there any way to get fight, ma'am?
Yes, consent of the
How
woman.
can she get justice?
So, Jita, consent of a woman is absolutely mandatory. I forgot to tell you that the Medical Termination of Pregnancy Act makes it mandatory for the woman's consent to be there. In fact, there was a very interesting case that the Supreme Court was confronted with. There was a woman with some mental retardation, a small amount of mental retardation, and she was in a correctional, she was in a home, like an institutional home for people with some disabilities, etc. And there she was abused. By that abuse, she became pregnant. She was raped, obviously, and that abuse led to it led to a pregnancy. And then the correctional home recommended that her pregnancy should be terminated because it will be very difficult for her to carry the pregnancy to full term and have a child. So the High Court allowed the termination of pregnancy. This woman came to Supreme Court and said, yes, I have this, deformity, this disability, but I still want to have a child. I want to have this child. I don't want to have this termination of pregnancy. And the court said it is her decision. It is her autonomy. It is basically putting the woman in the decision making. It will impact her body, her mental, her physical health the most. So she has to be at the driving seat of this. So MTP Act also very clearly says that without the consent of the woman, it cannot happen unless there is a medical emergency and the woman is not in a position to give a consent, because there may be times that the woman has undergone some medical complications and the doctor has to take that call. So the MTP Act makes an exception for those kind of situations, that if a medical practitioner is taking a call in view of a medical necessity in bona fide and good faith, then there will be protection. Otherwise, the woman's consent is a sine qua non for any decision qua termination of her pregnancy.
Thank you, ma'am. Thank you for clarifying my doubt. It really was a golden opportunity to talk with you, ma'am.
Thank you, Jita. Any more participants who would like to speak or share?
Yeah, hi ma'am, this is Chandni. Yeah, my question is like women being the decision makers in these particular rights, is this being taken as advantages in some cases? And how is law protecting justice in that particular cases where they are taking the leisure of these rights?
See, Chandni ji, any law is capable of being abused. It is not like, any law is immune from abuse. It will depend on, the people who are exercising those rights. Even the most sanguine rights of the Constitution and other statutes are abused. But that is why we have the system of the courts. That is why we have the system of justice delivery mechanism in different layers, so that the grain can be removed from the shaft, so that cases where where the any individual or any institution, anybody who's trying to circumvent the process of law, trying to abuse the process of law, can be held to account. Now, in this case, also for medical termination of pregnancy, up to 20 weeks, it has to be it has to be the decision and satisfaction of one medical practitioner. When it comes to 20 to 24 weeks, it has to be at least two medical practitioners. Now, these medical practitioners are defined in the rules, what qualifications they have to have, where these processes have to be carried out, what kind of documentations are required to be prepared, what kind of satisfaction, how it has to be recorded. So the rules do have a mechanism in place so that it doesn't become a easy rampant situation where at the drop of a hat there is termination of pregnancy, because the preservation of life is a very important aspect, which is the balancing part of it. So on one side is the right, the reproductive and sexual right of the woman, on the other side is the right to life of the fetus. So that protection, that thin line balancing of constitutional equities has to go on in a very sacrosanct manner. And if it goes beyond 24 weeks, also Medical Termination of Pregnancy Act allows termination, but that is only in case of fetal deformities, genetical deformities in the fetus, and there it is the medical board that that has to come to that finding. So the system of checks and balances is there in the statute, in the rules and the regulations, and then you have the courts of law to see that the abuse is either stopped or punished.
Yeah, thank you ma'am, thank you for the clarification.
Thank you, Chandini, for sharing your doubt. Any other participants?
Good morning, ma'am. Myself, Kusuma Swaraj. And my doubt is that in India, there are many backward classes areas where women are not allowed to go out or fight for their rights because of the customs and duties imposed on them. How does the law reach the poor, ma'am? Because there are many women where they cannot speak about what they are facing. How does law reach the poor? Many women who are very silent about whatever happening in the society. How does the law reach, ma'am?
You're right, Kusuma. That is a very serious predicament that continues to face our country and countries across the world, because having the rights, I think India is amongst one of those countries that we have the most sanguine laws in place. The whole system is in place, but there is still a huge gap between people who really need access to those laws, to that protection, to that vindication, and they find it very difficult. But let me tell you, I know from my own experience that the whole system, in that way, the system of the legal aid committees, which is governed by the 1987 Act of the National Legal Services Act, there is a system in place which starts at the top with the NALSA, which is the National Legal Aid Services Act, which is headed by Chief Justice of India. At the state level, there are state legal services authorities which are headed by the Chief Justice of each High Court. And then it goes down to every district level. And at district levels, there are the district judges who are the head of the district legal services authorities. Every district court in the country, this started in 1987, and now the reach of the Legal Services Act has percolated down to every district in the country. In fact, there are many small municipalities, small pockets also where legal aid committees are there, or there are, outreach programs that are being held. And it's a very strong mechanism that has been put in place where the funds are provided by the state, and the manpower is also provided by the state, and the supervision is of judiciary completely. So this is not everyone has, there are police stations, and you have people in theory have access to those police stations. But these legal aid committees, these legal aid centers, they have become a strong mechanism which is in place for people who don't have access to justice. These people, and a lot of universities, colleges, they're running their own legal aid centers, which are outreach programs, which they have a connect with the community and with the legal aid committees on one side. So a lot of law students and universities are doing this outreach, providing that bridge between the between lawyers and the victims who need access to justice. And let me also tell you, it is a matter of great pride for lawyers to be volunteers in these legal aid committees. So very good lawyers in all courts are volunteering for this. There is now a assimilation between the one-stop centers that have been set up in every district in the country, which have a paralegal worker, which have medical help, which has a social worker, which has a so these one-stop centers are providing psychological help, and these are specially for women who have been wronged, women who need the protection of law, the protection. Then they need medical assistance, they need legal assistance. So that mechanism is now in place, and that mechanism is doing well. But we are a vast country, the gaps continue to exist. I think more and more of us students of law should get involved in this mechanism and tell people, otherwise legal aid is available only to people. It's a constitutional mandate. Again, it started from part 4. It was a directive principle of state policy, which ultimately culminated into a 1987 act. And then the whole mechanism has been set up, and it is a very robust mechanism, I can assure you. I take a lot of pride in saying that ever since the beginning of my career, I have been a legal aid counsel myself, and it's a matter of great privilege and satisfaction to be able to give something back to or be of some help to the society. So please inform people, let people know that these accesses are available to them. They have good medical and legal help available to them at these places. And otherwise, if you need legal aid, you need to show that you are beyond a certain economic threshold, that you belong to that economically weaker society, that you don't have access to justice. So you need this legal aid, which is the state is providing. But if it comes to a woman, if it comes to a child, if it comes to any other vulnerable categories, disabled persons, etc., they have the facility of legal aid irrespective of their economic capacity. So they don't have to prove that they don't earn enough to have benefit of legal aid. All women related issues are covered under legal aid. Please inform as many people as you can so that they can have better access to justice.
Thank you, ma'am. Thank you so much.
Thank you, ma'am. Thank you, Kusma, for sharing your doubt. Anyone else who would like to speak?
Yeah, ma'am, this is
Please
Samir.
make it the last one. I have to go. I have some conferences.
Yeah, ma'am, this is the last one, ma'am. I am Samir. May I audible, ma'am? Ma'am, we are doing a lot of work with our DLSA, District Legal Services Authorities, and State Legal Services Authorities, but they are doing their calendar activities only. if this type of women reproductive acts and awareness, if they bring it to the village level and self-help group level in their activities, it will be good, ma'am. If you can suggest it from our Supreme Court to the NALSA, or from the Bar Association of Supreme Court to the NALSA or State Legal Services Authority, it will be very good. The women will be get knowledge on these related acts, because all of the women now are very much aware about uh, DVA, domestic violence, and other related acts, not on this type of acts.
I can assure you, Samirji, that a lot of good work is happening through the National Legal Services Authorities Act. But see, there cannot be any perfection. It is always work in progress. It continues to go on. After all, we are a very large country, very huge population, huge geographical areas. But because this is being driven from the top, right from the Chief Justice of India, the current Chief Justice, Justice Lalit, who's just taken oath yesterday, he was the executive chairman of NALSA for a long time as a number 2 judge, and he has done phenomenal job, and a lot of good work is happening. But see, it's a work in progress. We can add to it. I know of many colleges and universities who are running these legal aid clinics. As students of law, you will gain a lot more perspective, experience, and knowledge if you have these outreach programs for your community. And see how many law colleges we have across the country. If every college is running one outreach program, and speak not just about rights, speak about duties also, because rights do not exist in vacuum. Rights, every right, if my one right has to be exercised, everyone around me, like for example, today I am exercising my freedom of speech, every one of you is listening me out, you're hearing me out, you're not interrupting or abusing me, or so you are doing your duty for me to be able to exercise my rights. So rights are all collective. It's not one person's right that can trump. These are collective rights. And I think that's work in progress is all I can say. I know that good work is happening, but it has to continue to happen. I think I'll have to go. I have some conferences. Thank you very much for this opportunity. I think Dean sir wants to say something. We can then go.
Ma'am,
Nothing.
just a second. I would like to convey something. Behind the webinar, there involves a lot of effort. In this process, I have to address one special person, that is Manvendra Singh sir. Manvendra Singh sir is ma'am's son and colleague as well. In spite of your busy schedule, sir and you as well have given so much time and interest. You have given immediate responses. We are so privileged to have you, ma'am. Hope we do many more webinars.
Thank you so much, Jyotsna ji. Thank you for making it interactive. I also enjoyed myself. I loved this interaction. Dean sir, you want to say something?
Just 1 minute. I'd like to thank the chief, not the chief guest, the special addressee of today's national webinar, Miss Aishwarya Bhati, who has spoken extensively well about the topic. And I think there will be a lot of questions and discussions and debates going on in this country on this particular sensitive topic. So especially for the girls and women who are here, let me tell you one thing very openly, friends. Unless you assert yourself, the society is not going to give in so easily. First thing, as I have seen, men have to be educated, then the mothers and mother-in-laws. Because with the vast experience of more than 38 years as a student, scholar, and a faculty on the campus, have seen n number of cases personally and read how these three, the men, the mothers, and the mother-in-laws, impact women's reproductive rights. That's for sure. And if I share one example before our chief guest leaves, my person, because when you respect the women, then only these rights can be promoted. Let me put it very straight, friends. I got married in 92. Till 1998, we never had children. We don't want to have children. The reason was my wife was a part-time faculty, and there is a likelihood of she becoming a permanent faculty in the SP Women's University. And only in 1998 we had our first child, and it was never illegal anything. We went in a natural process. Natural process. Keep it in quote. There was pressure on me, pressure on my wife, from my friends, from my relatives, etc., etc. But we never budged. We never budged. The second child was born in 2000, the boy. So in that way, I can easily say that because all the practical things, the theoretical things will be implemented in practice only if we change our mindset. And unfortunately, in our society, I can say the educated men, especially when you have seen the last 2 years when the COVID was at its peak, they have troubled the women or the wives to such an extent. That is the truth. So laws cannot change anything unless we change our mindset. This is what I, as a student of political science and public administration, can openly say. Because law is there to tell these are the things which you should do, which you should not do. And it's the citizen, the common man in every country who has to act as per the law. That's why so many cases have gone to the Supreme Court, the High Court, the district courts. And still, people are, especially the women, are fighting for their rights. In the so-called the oldest civilized country in the world. That's very unfortunate. That's what I feel so. So with this, we can have a discussion further. I'd like to thank the special guest for making this happen, and especially Team Pawan. This is their 4th national webinar, and I'm only the HOD in charge for them. He always comes forward and says that we want to do something academically. Madam, if you can wait for 1 minute, just she will read my CV. She did not complete my CV. Then you can, how I inspired them. Just 1 minute. Joshna, just go ahead. Please read where you have left. So
it's my immense pleasure to speak about our Dean, B.V. Muralidhar sir. Sir has done Masters in 1985 and MPhil in 1987 and doctoral degree in 1995 from the same university. His area of specialization and interests are international relations and foreign policy. He joined department as assistant professor in 1989. Dr. Muralidhar is a member of various associations and academic bodies in India and abroad, and contributed research articles in national and international journals, books. He's a member BOS of other universities and colleges, and also colleges inspection committees. He has organized 2 national seminars in 1995 and 2006 and 1 international conference in 2019. During COVID time, Sir has organized 15 international webinars and 2 national webinars, all these with the anchoring by students. He is the author of 11 books and editor, article reviewer for 6 journals. He presented research articles both at national and international seminar conferences and visited South Korea, Malaysia, Netherlands, Belgium, Germany, Sweden, Norway, Denmark, UK, Hong Kong, Thailand, Nepal, USA, Vietnam, Republic on American politics and thought at UMass, Amherst, USA in 2007. He chaired technical sessions at national and international levels. Sir has successfully guided 14 PhDs, 9 MPhil scholars, and 4 postdoctoral scholars so far. Sir have given extension lectures, UGC special lectures, and academic staff college talks all over the country and in foreign nations too. Sir teaches modern political analysis, research methodology, international relations, and India's foreign policy at master's level, and earlier 1 course for undergraduate students of SPMVV, Women's University. At present, Sir is the Director, Student Welfare and Cultural Affairs of the university since 2008 till now. Apart from the academic profile, Sir has also Sir is also a good tennis player who has represented our university 3 times and played more than 125 tournaments at national, state, and local levels. Sir is a member SVU Cricket Selection Board. Professor Muralidhar sir is also a social service activist and doing social service with his family since 4 decades. Thank you
Thanks,
so much.
thanks, Josna. Thank you very much. And I think you are one of the active students of this particular batch. I have seen because I have been in on this campus for the last 38 years, as I told you, right from 1983 June, July, and I've seen n number of batches passing through. So thereby, with this kind of limited, I can say, academic profile, I could inspire many of the students. And one batch is this BL students. That's the only simple thing. So when they came to me,
Impressive, sir. It's very
Yeah,
impressive. And
yeah,
I
thank
think
you.
I must thank you for guiding the students so well. I think you have a great team. And I think if the students of law can stay curious for knowledge, the job is already done
Yes,
because
that's
the
correct, madam.
area will continue to develop. If you are curious, you will continue to find questions, raise questions, and then look for answers to those questions. So God bless you
all the academic activities of my department
Sir, I'll
are being
have to
done
go
by
now.
the students,
I'll
or
have to
by
go
the
now.
students only.
Thank
Only
you so
students.
much. Have
Yeah.
a God bless you all. Thank you so much.
Thank you very much. Thanks, madam. Hope to
Thank you
catch up
so much,
sometime.
ma'am.
Yeah, let's go ahead with whatever you want to ask some questions to me also. No problem. I like to answer, and we'll finish off by 5 minutes or 5 or 10 minutes. So as I told you, our mindset has to be changed. And I don't think so it's going to be very easy. See, the effort made by the legal illuminaries in this country will go waste if the common man's mindset doesn't change. Law will be only law in theory, not in practice. And if we do this, Ibrahim Sheikh, he was asking something. How can we be part of your academic mission? What's that? Sheikh, is he a student? Kalyan, student atano?
Sir, don't know, sir.
Okay. Ibrahim Sheikh, you're from
Not from SV University.
SVU. Okay, okay. I am from, you're from Hyderabad, Usmania University. That's good. Yes, that's good. Out of this, because you can join us there, any of the national webinars, online web programs, if they do this, the virtual ones. Because you can be in touch with our students, Kalyan and others, and get the information. So as far as from my side is concerned, whatever academic work you want, any help, I'm ready to do it. Because I always believe in teamwork, and I always believe in other thing, that after me there must be someone to carry the mantle. There must be someone. And for that reason, I always prefer not the faculty to do the anchoring, the students to do the anchoring. The students have to do the anchoring so that in future, this will be some kind of training for them when they settle down in some jobs, where this will definitely help. With that purpose only, all the 15 international webinars, the 2 national seminars, the 1 international conference were all done by my students and students of some other departments as anchors. And most of them are happy. So if you want to ask any question, you can for 5 minutes. Because I'm a student of political science and public administration, not from law. Because law and politics are completely different. When politics enter law, the problem comes for law. Okay, just go ahead. See, yesterday I was going through one article. It says that out of 195 countries legally declared by the UNO, in 93 countries, legally, there is a chance of the young girls becoming brides. That means more than 50% of the countries have that option, that young girls below the age of marriage, they can become brides. And 1 out of 4 women do not have the right to do abortion, even if it is going to affect their life. This is the kind of system in which we are living at present. That's why let us be practical. All the laws, the acts, the policies, the decisions taken by the government will never be successful unless we, the guys, change. And along with us, the parents' mindset should change. And mother's role is very, very important here. They cannot discriminate between a girl and a boy in her family. The sensitization should be done for men, for boys first. Then only these kind of topics will never ever be discussed. No need to discuss. Because I told you openly about my case. I don't have mother, I don't have sisters. My mother passed away in 1984. I got married in 1992. And my neighbors were very much interested when I'm going to have a child. That is a very peculiar thing in India. Your neighbors will decide when you should marry, when you should have a child, when you should go out with who. All these things happen in India only. Very unfortunate, and that too it happens to girls. But as far as my case is concerned, I can tell you very, very openly, guys, I'm very stubborn. Stubborn in the sense, not in a wrong way, in the right way. I got married when I have to marry, not when others wants to marry. I want to have my child when me and my wife want to have, not some XYZ wants to have. That's very sure. I'm telling you very openly. How many of you can say that to your parents? That we want to have the child at this particular point of time. Because my wife's health is not good, or she is not in a position to go for this family life or something like that. How many of you who are sitting in this particular event can say to your parents that I did? That's why I'm very bold enough to tell you. And I have a daughter and I have a son. I always tell this. Be bold. Tell bluntly. Otherwise, these men will take advantage. And using the wrong contraceptives, wrong methods of termination is going to affect the life of that woman or girl. Be careful, friends. This is a very sensitive topic, but yet it did not go into the minds of the people of this country for the last 75 years or earlier also, because we used to commodify women. Whether you take the ancient scriptures or the medieval scriptures or the modern scriptures, in most of the cases, women are being commodified. Thereby, Pawan and his team has taken up this issue. As we talk about communal rights, secularism, national integration, for years together, we have been teaching. Sometimes I feel so. Do we require for the last 75 years to talk about all these concepts? equal rights for women, discrimination, all these things. Do we require? That means something is wrong with the system. And the system consists of the people. And these people are to be sensitized. I want to tell you repeatedly, friends. Unless this is being done, nothing can help. Nothing. Yes, someone has said, keep volumes 3. This is a very sensitive. Yes. You have to put your foot down when it comes to your life, your health, not other person's life and other person's health. This is where women have to be very careful. The girls have to be very careful. That's why starts with 1 out of 4 do not have the right for abortion, even to protect the life, women's life in our country. This is what the statistic says. Even if the woman dies, the society is not bothered. They don't want to go for abortion. The other thing, as Josna was telling, the religion. People think that women are birth yielding missions, certain religions. We don't realize that they are human beings. One politician was telling, just go on producing children, more than 10 or 12. This has come last year. I have read that article also. I don't know how a politician in that particular position can talk openly. And there is no response from the women, whether in the parliament or in the assemblies or in the country in general. So he was just telling, just produce the children. More than 10. He is asking every woman in this country. That's why I'm telling you, the mindset of the men should be changed. Religion should not come into the private life of the individual or the couple. If religion, caste comes into this, nothing is going to work out. So thereby, when you are leading ones, because most of you are young girls and young boys, I'm telling you very openly, guys, listen to your partner, understand her, then you will have a good life. And for the girls, which I want to tell your partner, talk to him when and how these things should be done after you get married. So if there is no communication between the wife and the husband, there will be health issues. And once health issues comes, the men will be safe. It is the women who will be suffering. In one case I have seen, one of my friend's father was asking, he already had 2, go for a third one. Then that guy said, no question of third. 2 is enough. He is my close friend. And both wife and husband are working. Maintenance is not a big problem for them. So that's what I want to tell after seeing so many boys and girls on the campus. Put a stop where it has to be. Put a stop where it has to be. Whether it is with your parents, whether it is with your husband or wife or anyone. If you don't do that, you are the one who has to face all the dangers which the speaker has said just now. And no law, no religion, no caste will protect you. This is for sure. I know many women died, many women had health issues because of adopting illegal birth control methods. The religion did not come, the caste did not come, the parents did not come to the rescue. So be careful, guys. This is not an easy thing, the most difficult, but yet you have to be. Because you are the one who will be the future citizens of this country. And see that your better off is also healthy. So with this, I once again thank Team Pawan and each and every one of you for sparing your time, especially on Sunday, to be here with us and listen to the topic chosen by the students of 5 years LLB program of my university. Thank you once again.
Thank you so much, sir. I extend once again huge gratitude towards you. You are always being supportive, always shower support on us. Thanks for being the main pillar behind the webinar. Thank you so much, sir. And now it's time for formal vote of thanks. Over to Sandeep, who will deliver the vote of thanks. Sandeep.
Yes. A warm and peaceful morning to everyone. I am C.H. Sai Sandeep, student of SV University, Department of Law. Today it's my privilege to propose vote of thanks and acknowledge the contribution of those who worked really hard to make this event meeting possible. First of all, I would like to thank our distinguished speaker, Mrs. Aishwarya Bhati, Additional Solicitor General and Senior Advocate of Supreme Court. Ma'am, for your presence and making this event meaningful. It's been an opportunity to all of us to hear. We have got a lot of information. I would also like to extend my thanks to Professor B.V. Muralidhar sir, former principal, SVU College of Arts and in charge HOD Department of Law, for his presence and who made this seminar a grand success through their motivation and dedication to. Last but not least, I thank all the students for your cooperation in making this event successful. Thank you one and all. Thank you.
Thank you, Sandeep. Once again, thanks to B.V. Muralidhar sir for sir's kind gesture and presence. Thank you so much, sir.
Nothing. It's my pleasure. Because as I told you, I always believe that someone should be there to carry the system. Okay? Thanks, Kalyan. Hope to
Thank you,
meet
sir.
you. Yeah, next month with one more webinar. Okay?
Sure, sir.
Month ending. Yeah, you can have it after your classwork and all those things, exams.
Definitely, sir. Also, few of participants also messaging, sir.
Yeah, please message and send me the text.
They are also very interested. Actually, this time particularly, we
Yeah,
have
Ibrahim Sheikh.
students
I think
also.
you can include. You can include Ibrahim Sheikh also. I think he seems to be very active.
Sure, sir. Sure, definitely. Also, we also create one group also, sir, in WhatsApp.
Yeah, that's better.
Yeah, helpful. Sure. Thank you,
We
sir.
can invite you. You can invite him, especially for this virtual, if not physical. Okay.
Sure. Thank you, sir. Thank you so much.
Thank you. Catch up, guys.
Thank you.
On
Thank you
Monday,
so much.
Tuesday. Thanks, Sandy.
Once again, thanks to all the participants for being so cooperative and so supportive throughout the entire session. Thank you, everyone. Jai Hind.